Welcome to the debate on the economics of non-compete agreements and the FTC ban, an ABA antitrust law section brought to you by the Economics Committee and the Our Curious Amalgam podcast. I am Sergei Zaslavsky from Melvin and Myers. There's been a lot of discussion of non-competes over the past couple of years, and a major driver of that has, of course, been the FTC non-compete ban. FTC issued the proposed rule in January 2023, and then issued the final rule in April of this year. Non-competes, as defined by the FTC rule, are contractual provisions that prohibit workers, penalize workers, or function to prevent workers from seeking different employment or operating a business. And the rule is quite broad, banning all new non-competes and making existing non-competes non-enforceable, except for those with senior executives. There's a lot of discussion over whether the FTC even has authority to issue this rule, and this is currently the subject of litigation, and also the subject of an upcoming ABA Trust and Trade podcast episode, which is scheduled to drop on July 8th. But that is not the subject of this program. This debate is about the economics of non-competes, not the legal questions about the rule. Though, of course, economics have implications for policy, so we'll touch on policy as well. Economists have been studying non-competes for a while now, taking advantage of natural experiments afforded by different state-level rules about the enforceability of non-competes, as well as other research techniques. And in this program, we have two economists debating what we already know about the effects of non-competes on workers, on product markets, and on innovation, what we still have to learn, and what all of this means for policy, whether the FTC rule is a good idea or if it goes too far and sweeps too broadly. And when I describe this program as a debate, I use the term somewhat loosely. This is more of a cross between a discussion and a debate, because I think we'll see there are many areas of agreement, as well as some very interesting areas of disagreement. And joining me today as co-moderator is Anora Wang from Arnold and Porter. Anora, do you want to introduce our debaters and say a couple of words about the program?
Sure, and thank you, Sergei. Today we're in a treat. We have Evan Starr, who is Associate Professor of Management and Organization at Robert H. Smith School of Business at the University of Maryland, where I also attended not the business school, but the university. So not saying I'm biased, but welcome, Evan. And we also have Brian Albrecht, who is the Chief Economist at the International Center for Law and Economics. When you're not debating, and Brian, I'm rooting for you too, just so that, to show that I'm not biased. When they're not debating, you may find Evan in a swimming pool around 6 a.m. in the morning and Brian on a marathon track. You'll not find, I guess, not myself or maybe Sergei, either places. Just a reminder that we also have economist who is also a regular co-host of our Curious Amalgam, Panos Dimitralis, who is monitoring the Zoom and YouTube chats where the audience can post questions and comments. So if you're lucky, some of these questions may find their way to the speakers towards the end of this program. Just another reminder, this program will be released on a later date as an episode of the ABA Antitrust section's Our Curious Amalgam podcast. The section does have another podcast program called Trust and Trade, which will air an episode on July 8th, focusing on FTC's legal authority to issue the non-competes ban in a debate between former FTC acting chair Maureen Hausen and legal director of the Open Markets Institute, Sandeep Vaheesan. So it's really a lot of program coming up, but we cannot wait to have the debate kick off now.
All right. Thank you, Anora. And to kick off the debate, let's go with our first question. When we're evaluating whether a non-compete ban is justified from an economic perspective, I think a real natural place to start is what are the economic effects of non-competes? And specifically to begin with, what are the economic effects of non-competes on labor markets? How do they affect workers, both the positive effects and the negative effects? And let's start with Brian first, and then we'll go to Evan.
Well, first of all, thanks for having me. Excited to have this conversation. So economics, one of the things that we'll bring to any of these discussions is kind of a theoretical lens in which we'll interpret the evidence. So I'm going to talk a little bit about the theory behind it. The question is, why do firms and employees agree to sign non-competes? One mutually beneficial reason, possibly relevant, but at least theoretically relevant, is that it encourages both sides to invest in the relationship. If a worker is going to learn something on the job, whether it's a skill they developed, whether it's a secret of some type, okay, and then they could possibly very easily leave and pass that on to someone else, that's going to, if we roll back the time period, that's going to cause the firm not to give that information, not to provide that training. And so a non-compete, just as any sort of contractual arrangement, part of that arrangement is to try to encourage people to like bind their hands in a way to encourage a good behavior. And when economics thinks about investment in workers, it's not really about like whether the firm deserves some return for its investment or not. It's, are we going to encourage mutually beneficial investments in workers? Okay, so that's kind of the beneficial reason, kind of, if all things are good, this is why we'd expect it along with other contracts. There's also possibly concerns if they increase labor market power somehow that can allow one, it can allow firms to drive down wages for workers. And if you're worried about workers more than firms, that could be a problem you're thinking about. And it can also just discourage work on other dimensions. So if a firm is getting most of the rewards from hard work, you're not going to get hard work from the employees. And so there might be some, yes, from the firm's perspective, a non-compete is good because it extracts surplus, but from kind of overall perspective, it's bad because workers aren't working as hard. Okay, those are kind of the direct effects. There's a second type of effect, which is how does this then affect labor markets overall? And this one, again, it could go both ways. If the non-compete encourages investment, that investment could then be picked up by other firms down the way. If the non-compete discourages workers from moving, that could then gum up the labor market, slow down reallocation, kind of a negative. You and me signing a contract, harming the overall market. So from a theory perspective, it's kind of could go either way. And it's just in the last decade, really, that we've gotten more and more empirical work to kind of sort out which of these effects is more relevant. I'll let Evan kind of take the lead on that point.
Yeah, thank you so much, Brian. And thanks again to Sergei and Anora for having me here. It's really a delight. I've been studying non-competes for a little over a decade now. And what is fascinating to me about this topic and why I keep doing more and more studies on it is precisely because of this kind of theoretical tension, which is that we do have these arguments which are theoretically valid, that non-compete agreements are ways to protect information. If I have a trade secret, like the formula for Coca-Cola, let's say, and I have a worker named Brian, and I'd like Brian to be my master brewer, I have to share that trade secret with Brian in order for him to do his job and for me to sell Coca-Cola and do well in the market. And I'd be nervous that Brian might take this very valuable trade secret and walk across the street and sell it to a competitor. And so a non-compete is one way to protect that trade secret, and therefore one way to encourage Coca-Cola to invest in developing valuable trade secrets that might be beneficial for consumers. And on the same side, the non-compete agreement is only one way to protect those trade secrets. You also have less restrictive ways. A non-compete is very blunt in its protection. And the reason it's very blunt is because it precludes Brian from joining another company in the industry altogether just to protect that trade secret. Well, we have other tools like non-disclosure agreements, a whole body of trade secret law, trinary payment agreements, agreements not to solicit clients, all sorts of less restrictive agreements that are more directly tied to what they're protecting. Whereas a non-compete agreement is sort of a catch-all, just it blunts mobility and therefore protects in doing that. And so that's sort of the positive argument for non-competes. And I think the negative one Brian explained correctly, which is that non-competes are a direct restraint of trade, not only in labor markets, but also in product markets. They tend to directly prohibit a worker from joining a competitor or starting a competitor, often for a year or two after they leave. They tend to have a geographic restriction, though not always. They can apply even globally. And so there is this tension about which of these theories is right. How should we think about non-compete agreements? And so I think the place to start is with, where do we see non-compete agreements? And if you think the non-compete agreements are really about protecting trade secrets, about protecting valuable information, then you would expect them to be isolated in sort of the upper echelons of the labor force, workers with, who have access to this sort of information. And that is true to some degree. Tech workers sign non-competes at rates of about 50%. Executives sign them at rates about 60 to 80%. And those are sort of the highest estimates we have across the labor force. I think where it gets tricky is that about 30% of companies use non-compete agreements for every worker at the company, regardless of their level, regardless of their salary, regardless of the types of information they might have access to. And this is where you can get some extreme examples like the temporarily employed Amazon packer who signs an 18-month non-compete that's global. This is where you get volunteers at nonprofits signing non-compete agreements. This is where you get janitors, some of the extreme examples you might have heard. The contract can become embedded in the boilerplate, and they end up getting deployed to all sorts of workers. And so the number of workers with non-competes estimates vary across the US. On the low end, they start at around 16%. On the high end, they get up closer to 30%. And so it sort of depends on which survey you want to draw from about the use of non-compete agreements. The way that economists have tried to estimate what happens because of non-compete agreements is they've looked at surveys where they've asked workers what's happened because of this non-compete, and then they've looked at natural experiments where states have started changing their policies on non-competes. Some states have more vigorously enforced them. Some states have banned them for a lot of workers. Some states have banned them for a few workers. And in a recent paper, I'll just summarize briefly, we study all bans on non-competes for low-wage workers, which started in Oregon in 2008, and including high-wage workers, like the ones we saw recently, or even high-tech workers, which is what we saw in Hawaii in 2015. And if you look at across all of these bans on non-competes, wages tend to rise about 2 to 3% on average across the whole labor market after these bans take effect, whereas job mobility also tends to rise. And so if you thought that non-compete agreements were beneficial to workers, then banning them should have hurt workers. And it's the opposite that we saw. We saw that when they banned non-competes, that the workers actually benefited, job mobility tends to rise, and entrepreneurship tends to rise. And so I think some of these studies have started moving the needle on how to think about non-compete agreements alongside this kind of broad evidence that non-competes are being used with workers that you might not expect them if you thought non-competes were really about protecting valuable firm secrets.
I think that's very helpful. Thank you, both Brian and Evan. And Evan, you already mentioned the natural experiments in various states, which we'll get to later. And this is still very much on the labor market. But let's focus on products market for a second. And I think, Evan, you already mentioned that a little bit to the less degree, Brian. But let's focus on the product markets and maybe innovation in the product markets. We're not talking about innovation in the labor markets as of yet, right? Even though AI is coming soon, so we don't know. So just a straightforward question. What are the economic effects of non-competes on product markets and innovation? Evan, let's start with you.
Yeah, it's a really great question, Anora, and I think that it's right to think about the effects of non-compete agreements on labor markets and product markets, because they're restraints of trades on both markets, and they could reasonably affect both workers and consumers. And so let me first break down your question into maybe some sub questions that are a little bit easier to answer. So one kind of natural question is, do we even need non-competes to protect trade secrets in the first place? And so when you think about me using my Coca-Cola formula and giving it to Brian, do I need the non-compete to actually protect that investment, or would I have made that investment otherwise, even without the non-compete agreement? And so, this is really a question about what's the value add of the non-compete relative to alternative protection tools. And if it's true that NDAs, for example, or trade secret law are adequate in that they protect trade secrets, and that they would have encouraged Coca-Cola to create that formula in the first place and to share it with Brian so that he could be productive, then the non-compete added on top of that is not actually protecting the firm or spurring any more investment. The only thing that it's doing is it's taking Brian and it's making it harder for him to start a company if he wants to, and preventing him from taking better job offers at competitors. And so I think a place to start is, what is the efficacy of non-competes relative to the alternatives? And we have a very recent field experiment that I ran with Bo Cowgill and Brandon Freiberg. And what we did is we worked with a company in the financial services context, and we hired about 2,000 workers, and we randomized whether they had a non-compete. And then the group without a non-compete had a non-disclosure agreement. And then what we did is when we worked with these workers at one company, we gave them some secret information. And then after they were done with their job with the company, we worked with a second company and we tried to hire everybody. And one of the things we're looking at is who breaks their non-compete, but we also wanted to know who shares this secret information that we gave to these workers at the first company. And what we're looking at in particular is, do the non-compete agreements, when added on top of an NDA, do they actually dissuade secret sharing relative to those with only a non-disclosure agreement? And the answer was pretty clear that the non-compete agreements did not add anything to secret sharing, even though they did preclude workers from taking job offers. And so I think this is sort of some of the first direct evidence on this question about whether other tools are efficacious and whether non-compete agreements are necessary to protect firm investments. There's lots of concerns about generalizability. So there are a few other studies here I'll just mention briefly on this question, and then I'll turn to the broader points on innovation. So there's another recent study by Hiraiwa et al., which looks at whether firms value the ability to enforce non-competes. And in this study, what they're looking at is a Washington state non-compete ban, which in 2020 banned non-competes for workers making less than $100,000 a year. And this sets up a really interesting experiment, which is that if you take a worker who's making $99,000 a year, before the law came into place, that worker's non-compete was potentially enforceable, subject to the reasonableness test in the state of Washington. But in 2020, that worker's non-compete is per se unenforceable because they're under the threshold. And so the firm doesn't have to keep their wage at $99,000, though. They could just give them a very small raise to get them to that threshold and then have the opportunity to enforce their non-compete should they want to. And so the test then is, if firms really valued that ability to enforce their workers' non-compete, they would have paid that worker at least a small raise to get them to that threshold. And yet in the evidence, we didn't see any evidence that firms were paying workers to get them to this new threshold established in the law. And so we surveyed Washington employment attorneys who told us that the reason that they're not giving these workers wages, in part, is because they have other tools to protect their interests. Okay, so that again suggests that other tools are sufficiently protective. And I'll just raise one more, which is that there's a study by Brad Greenwood, Bruce Kobayashi, and myself, which looks at what happens to trade secret litigation after non-competes are banned. And the argument is very similar. It's that if you ban non-competes, workers are going to move more, which they do, and then they're going to share secrets more, which we can't observe. But if they do share secrets more, then we should potentially observe trade secret litigation rising, which is what you often hear. And so we looked at what's happening in trade secret litigation after states ban non-competes for low-wage workers, for high-wage workers. And what we find is that trade secret litigation doesn't rise either. In fact, in the long run, it goes down. And so this also suggests that even though workers are moving more, they're not necessarily sharing secrets at any higher rates. Okay, if you look more directly at other studies of innovation, there's two recent ones which exploit about 40-some non-compete changes over about a 20-year period, which ends in 2014, so before these major policy changes happened. But both these studies, one by Johnson, Lipsitz, and Pei, and the other one by Reinmuth and Rockwell, both find that when you enforce non-competes more vigorously, that innovation tends to fall, that entrepreneurship falls, job-to-job mobility falls. And even though, and this is I think to reconcile some of the tensions here, the Johnson et al. Study finds that when you enforce non-competes, firms do invest more, but the net effect on innovation is a drop. And the reason that that happens is because firm investment is only one input to innovation. You need other inputs as well, like the ability to hire the right types of workers, to pursue the right ideas, the freedom to go start your own company if you want to pursue those ideas. And so their kind of way they reconcile this theoretical tension is that, yeah, firms might invest more because of non-competes, but the net effect is still a drop in overall innovation.
Brian, let's turn it to you.
Yeah, so there's a lot of things in there that I kind of want to think a little bit more about, talk a little bit more about, particularly around, Evan is setting it up in terms of trade secrets, and that's obviously a huge part of this discussion, especially lawyers start thinking about trade secrets and get all excited. But I would couch it more generally in training, more, all sorts of types of training falling under that. And the little bit of evidence we have, it's not great. A little bit of evidence we have suggests that increasing the enforceability of non-competes increases worker training. That's more broad than just the Coca-Cola trade secret. Can I say exactly what it is? No, how great are we measuring it? I don't know. There's a lot of different things, but there's a little bit of evidence that these are having some effect on training. And so that seems relevant for all of the other effects that we're interested in. We're interested in wages. Well, if that effect shows up in wages just today, Evans studies would have picked it up in Oregon. If that effect shows up in 5 years, 10 years, it'll be harder to disentangle. And that's just the nature of these kind of long-term things as long-term investments. And so there's a lot of tensions here about what different studies find in terms of kind of, yes, the question's about product markets, but I think it's, as Evan pointed out, intimately related to labor markets. It's very few products involve zero labor. But let's circle back a little bit to the output markets or anything that's kind of non-directly labor. We just don't have much evidence on it, which is the nature of this, it's a nature of labor markets. We also don't have many studies that look at minimum wage that then look at output markets. There's a few, but it's not many, because it's kind of hard. The way labor economists think about things and study things in the surveys that they have is a little bit different than people who look at output markets. And so there's mixed evidence. The only evidence we have on prices doesn't seem good, but that's from healthcare, and there's a lot of other weird things happening in pricing there. There's mixed evidence on business entry, which is kind of a proxy or a first step before you get more output and more innovation. Again, there's Florida had a policy change, but it's not super clear what it was, and that suggested increase in the number of establishments, basically number of businesses, not number of like plants in a firm, if you think of a manufacturing system. But other studies looking at Michigan, looking at LinkedIn data find the opposite. And so there's a few studies on output markets, but really not a lot. One that I think is really interesting is one by Marx that seems to suggest one of the findings is that female entrepreneurship drops a lot with more non-competes. And so one of the effects could be of non-competes is this kind of, especially for if they're subpopulations that are a little more risk averse to lawsuits, that you're going to see a disproportionate effect on them. I don't know how serious to take that as like an overall statement about output and innovation and entrepreneurship, but I think it is a really clear study on how some people are super scared of being sued, and therefore there could be having spillover effects, indirect effects in different markets.
Well, very interesting stuff. And I'm going to drill down a little bit on something you mentioned already, which is alternatives to non-competes. And it sounds like we all agree that there are some legitimate justifications for non-competes: protecting your trade secret, being able to invest in training without being afraid that your worker is going to free ride on that training, take the training program and then leave as soon as the training's done. And it sounds like there may be some alternative ways of achieving these goals. But are these alternatives really as effective as non-competes at accomplishing these legitimate goals? For example, I might have an NDA to protect my trade secret, but how do I know if my employee is giving away my information? It might be really hard to get evidence of that and pursue a trade secret lawsuit. A non-compete may be just a much more secure way to protect my information than an NDA. So do you guys want to weigh in on the evidence, the theory on how good these alternatives are for attaining the legitimate goals of non-competes? And let's start with Evan here and then go to Brian.
Yeah, it's a great point. And as the author of several of the training papers that Brian referenced earlier, it's true that workers with non-competes tend to receive more training. It's also true that in states that enforce non-competes more vigorously, that workers tend to have more training. I think part of the challenge is that in no state in the U.S. is general training a legitimate business interest, as the lawyers would have it. In other words, you cannot file and enforce a non-compete agreement in any state on the basis that you provided the worker with general training. In some states, they have carve-outs for specialized training. And so here's the way that I think about non-compete agreements when it comes to sort of general training, which is that the non-compete agreement does two things. One is it should be protecting information. That's the justification. So trade secrets, client lists, company goodwill, it should be protecting that stuff. But it also is going to have this direct effect on employee mobility because it's a restraint of trade. And anything you do that restricts employee mobility is also going to spur firm investment. And the reason for that is that if a worker is going to stick around at your company longer, then firms are going to receive greater returns on investments as the worker is there. Maybe they're there for 5 years without a non-compete, 10 years with a non-compete. That's 5 extra years that you get a return on your investment with regards to training. And so the thing that I want to say is that a non-compete agreement, imagine you had a non-compete which actually only protected trade secrets and didn't affect employee mobility. I don't know if we would get the investment responses that we've seen in some of these studies. In other words, they could be coming simply through restricting employee mobility, not through actually any additional protection whatsoever. And I think that's at least if you take the experimental finding that I described earlier, at face value, that's sort of one interpretation of these investment results, that they all come from protecting employee mobility. That said, let me just talk about alternatives very briefly. And on the training issue, there's these, there are training repayment agreements, which are a natural alternative. I teach MBA students. Many of them love the fact that their employer pays for their MBA, and then they have to stick around at the company for 2 years or so afterwards. And if they leave early, they have to pay some prorated portion of the MBA fees that they didn't get to recoup while they worked there. And so the reason training repayment agreements are a nice alternative is because they're directly tied to the outlay, right? It's like, here is an investment I'm trying to protect, and so here's how I'm going to protect that. If you contrast that with a non-compete, if a non-compete is being used to justify training expenses, then why would a non-compete apply 10 years, 20 years after the training has already been provided and the expenses for the training have been well paid back? And so if the argument for non-competes is, we need training, well, then maybe the non-compete should also expire once the training has been recouped. There are other issues with some of these alternatives. I'll just mention them briefly. So training repayment agreements can be written very broadly, especially when training is tacit. There's some extreme examples in a recent paper by Jonathan Harris of when the company has really inflated the training expenses. There's other examples where firms have really snuck these expenses into contracts, and unwitting workers have realized that just to leave their job, they have to pay an enormous fee, and they were unaware. So there are some other issues with these. The only real study on training repayment contracts is done by Mitch Hoffman and Steve Burks in the trucking industry. I'm not aware, maybe Brian, you're aware of other ones, but in this one, they did find that the training repayment agreements were effective in retaining workers and keeping them around, which is a big problem in the trucking industry.
Yeah, that's the most direct. The training of the truckers is the clearest example, and they have the best data on actual output of the truckers and stuff like that. So they're able to. One hard thing in any of these studies and thinking about turnover is there's like an optimal amount of turnover. Generally, especially macroeconomists think that just labor churn is like a great thing, but for each firm, that's obviously not true. Like the trucking companies have a huge issue with retention. McDonald's famously, I don't know if this is true anymore, but famously had a lot of trouble with retention. And so you want workers to stay around a little bit. You don't want them to stay around forever. And so it's kind of a balance here. One thing I'd talk about with alternatives is that it kind of, absolutely, there's a lot of other alternatives. And I really think we should find, ways in order to, encourage those when those are actually what's needed, the repayment agreements. Although, to what extent the FTC is going to look favorably at different repayment agreements might be a question, but not a lawyer here. But I think the problem, and this is getting a little bit ahead of ourselves, is not every non-compete has the same justification. So sometimes a lot of the justification seems to be that it's just easier to have one contract for everyone. Now, is that a good justification or not? Probably not, but it saves some resources on the lawyer's part. I mean, the lawyers would like having more and more contracts to spend more time on it. Other times it's more like the trade secrets. Other times it's maybe more of the investment. And the question is, to what extent is it kind of a one-size-fits-all? We'll get into this one-size-fits-all. And to what extent are we as the economists or the lawyers or the people studying it even like going to tease out all of the alternatives and where they are? Evan's done this study that Evan's talking about with experiment, super cool. It gets into this non-disclosures versus non-competes, but in a new situation, where is it going to be? Now that I don't want to keep moving the goalposts in the sense of just like, oh, there's always another justification these could be used, but there's always another justification for why these could be used.
Really interesting, guys. And it sounds like we agree there are legitimate justifications here. And that seems to suggest that there may be circumstances where on balance, a particular non-compete may be justified and may be socially beneficial. And other circumstances where maybe the negative effects outweigh the positive ones, so the non-compete is harmful. So from your point of view, which error costs are greater here? Is there more risk from having overly aggressive enforcement that may ban some of the socially beneficial non-competes, or more risk from having lax enforcement that may allow some harmful non-competes to survive? Let's start with Brian on this one.
Yeah, it's really the kind of the crux of the issue. Two things I want to point out before kind of answering that question directly. So one is just the stage at which we're at in terms of knowledge, and we start thinking about costs and benefits here. Evan talked earlier about how the best studies, his studies mostly, and that's not, I'm saying that's not me, his studies, especially in Oregon, find around a 2%, 3% increase in wages, and that's a wonderful thing. There's not a ton of studies because we haven't had a ton of clear experiments like the Oregon. We've had a few. We'll have another one relatively soon as people start to dig into Minnesota, which had a complete ban. That's where I'm at. So just in terms of this air cost, which way are we thinking about it? I think it's fair to say that our expectation should be that 2%, 3% number because of the best studies. That's what we find. The question is, how confident should we be in that number? How much of our belief is at that 2% number versus 4, 1, -1, type of thing. And so that's a tough question. For me, thinking about errors, one thing that comes to mind is because we have so few studies and so few clear examples of this, I think there's concern about overcorrecting. In particular, I'm concerned that with the ban, if it goes into effect, the nationwide ban from the FTC, and it turns out that and the challenges fall through and actually the ban gets implemented and yada, yada, yada. And it turns out that actually the best studies find a -1% increase in wages that hurt wages. The ban hurt wages. Will it get repealed? What would be the effects if it does get repealed? So maybe the next FTC or 2 FTCs from now is a Republican one and they try to repeal it. Okay, well then how are firms going to use non-competes when they think that the next administration is going to reverse it, and the uncertainty that causes. That causes me more concern than I think it causes most economists. Putting my cards on the table, I'm a little bit worried about that lack of feedback, but that's why I'd rather stay on the path we're at. There's costs to that when we talk about that, but I'd rather stay on the path we're at where state by state are kind of discovering what is optimal for them.
Yeah, so I think this is a great question about the risks of a ban, a complete ban, versus something like the status quo where we have this state by state regulation. So I guess I have several thoughts and then maybe some reactions to Brian here, which is that non-compete policies in the U.S. has actually been quite stable since the late 1800s. California and North Dakota and Oklahoma banned non-competes in the 1800s. And then there are some small changes over the years, but really it's not until the early 2000s when states really begin to change their policies, with Oregon in 2008. And if you read the literature around then, what you'll find is that Oregon policymakers began to find non-competes in low-wage workers' contracts where they thought they didn't belong. And that really surprised them because they thought they were only being used for sort of tech workers and executives. And so they passed in 2008 this ban on non-competes for workers earning below the median income for a family of 4 in Oregon, which today is, I think, around $120,000 some dollars. If you then fast forward in time, what happened is in 2014, 2015, several extreme examples of non-competes came out. The Jimmy John's sandwich makers, the Amazon packers who were employed for just a few weeks over the holidays, getting paid minimum wage, the non-competes in California being found out. And this is what spurred the last decade of policy action that we've seen, combined with the new evidence that we've had. Really, it was in 2014 when we came out with our first survey, national survey of non-competes. We've done, I don't know how many since, maybe 5 or 6. Before that, there were just several kind of scattered studies. And so what we've learned here over the last decade is a lot about non-compete agreements, and it tells us, I think, a lot about the status quo. And you know, here's a really important thing that we've learned, which is that non-compete agreements, they matter regardless of what the law in the state actually is. So I'll just give you some examples. I told you in California they banned non-competes in 1872. Most studies find that non-compete agreements are just about as common in California, where they've been unenforceable for over 100 years, as they are in other states. And that's not true in some studies of highly skilled individuals like executives, but they still sign non-competes in California. And the problem with this is that under the status quo, firms can basically get away with using totally unenforceable non-competes that courts would sanction. The FTC brought a case against Prudential Security in Michigan, who used a non-compete that had a $100,000 penalty attached to it. A court in Michigan found it overbroad, and that company kept using that non-compete. And there's several examples like that. So we have non-competes being used where they're not enforceable. We have non-compete agreements being used where courts have explicitly deemed them unenforceable. And then the question is, what do we make of those unenforceable non-competes? Well, if we come back to the pro-competitive ideas we've had before, those non-competes couldn't support any investments because at the end of the day, the courts wouldn't uphold them. And so it can't be the case that the firms are necessarily relying on them to make investments that they would have in potentially states that enforce non-competes. And at the same time, those non-compete agreements are perceived by workers to be enforceable. We have a paper called Subjective Beliefs About Enforceability, where we asked workers, what do you believe about your non-compete? And it turns out it doesn't matter where you are. It doesn't matter what your state laws are. Most workers are uninformed about their non-compete agreements. Even when they're per se unenforceable, workers behave as if they're unenforceable, and firms can still threaten them. They can still remind them of their obligations, and that drives a lot of behavior. And so in that situation, what you have is a bunch of workers who are responding to unenforceable contract terms, which are not being used for pro-competitive purposes, and they're just misallocating labor and preventing workers from taking jobs that they would like to take and starting companies that they would like to start. And I think that's a really big problem. And even if you change a single state policy, as we've seen, we don't get non-competes being removed from workers' contracts, as we've seen in California. And so I think this is the status quo. And the question is, are we comfortable with this status quo going forward? And what the FTC does, which these other states have not done, is to say it is unlawful to use a non-compete agreement or to ask a worker to get into a non-compete agreement. And the vision, I think, is to remove them from the contract entirely so that workers can't be subject to threats from attorneys, from the lawyers, that the companies that are hiring these workers, they can't be subject to threats over violating a non-compete agreement. And my view is that one of the biggest costs to the status quo is that we have a whole bunch of workers who are under totally unenforceable non-compete agreements who are nevertheless abiding by them. And that by taking an approach like the FTC, where it's across all 50 states, where companies can't forum shop and choose different choice of law and choice of forum clauses, that this actually creates a lot of continuity. It allows for better information for workers to know their rights, and that we could see a great reallocation of workers across companies. And so my view is the status quo has a lot of costs with it. It's very difficult. I mean, just a side point here, it's very difficult for companies to manage multi-state locations when they have such different policies. It's difficult for workers because you have all these issues about which state law applies. And so in my view, the cost of keeping with the status quo is quite large, especially in light of all of the evidence that's come out on the effects of innovation, on labor markets. And so my view is that the cost of keeping where we are is quite high.
Let me ask you a related question. You talked about uniformity across states. One other aspect of the FTC rule that's really interesting, it's uniform across all kinds of non-competes. Now, usually when we have a practice that has some justification, some negative effects, we do a rule of reason analysis. We go case by case. But this is a per se ban, which is somewhat unusual for practice where people acknowledge there are legitimate justifications. Does it make sense to have this per se ban across all non-competes? Or is a case-by-case approach like we usually use for restraints that have some positive justifications, have legitimate justification, more appropriate here? Let's start with Evan on this one and then go to Brian.
Yeah, so I think that the first point, just to build off of what I was saying earlier, is that if you have a case-by-case approach, then you admit all of these potentially unenforceable non-compete agreements, where at the end of the day, the worst case thing that happens is a court says you can't use it, but then you just go back to using it. I think that is a major challenge here, because, and I think that it was really Alex Tebrock who put it very well. He summarized an argument by Ron Gilson from the 1990s in a very succinct way, which is that if everyone else can use non-compete agreements or is using non-compete agreements, you'd like to hire their workers if you can. But if they have non-compete agreements and you as a firm can't hire from them, but you're not using non-competes with your workers, then they can hire from you. And so it is privately optimal for companies to try to use non-compete agreements where they can, because you can only control your workers to some extent. You can't control what's happening elsewhere. And so if everyone does this, then we end up with this privately optimal situation where companies are using non-competes to restrict their workers, but we're then worse off as a society. And the reason is because now who's in a market with lots of non-competes, who's going to start a new company? Who are you going to be able to hire if you're a company? And I think this is where a per se rule sort of helps break this privately optimal equilibrium that is suboptimal from a social perspective. The second thing I'll say on this is that if you want to start thinking about how you get to a per se ban when you think of different types of workers, I think that if you just start with executives, this is where sort of the rubber meets the road, because executives are the ones who know everything about the company. They can't be coerced into signing non-compete agreements. They're sophisticated. If they were to go and leave the company and use all of the information and secrets they have access to, it might be considered unfair competition. And so this is sort of the test case where, you might argue that the value of the non-compete is the highest among executives. And so the question is, can you justify a ban for an executive? And if you can, then you can probably justify a ban for most other workers. And so how do you justify a ban when you have a very sophisticated individual, where we are going to see the pro-investment effects of non-compete agreements? And the answer, based on the literature, is basically that there are third-party harms, that there are other units in the economy who are affected by these contracts. And so the literature has identified several of these. There's a recent paper by Leon Shi that I'll just highlight, which says that other firms may not be able to access the executive that they want as a result of a non-compete sign. So if an executive signs a non-compete with firm A, that's very broad, they won't necessarily be able to work for firm B. Even if they're a much better fit at firm B, if their productivity is much higher, they wouldn't be able to, because the terms of the non-compete would be too restrictive. And so in her model, she looks at only that dimension of spillovers. And her findings suggest that even in the case of executives, that a non-compete agreement is a ban on non-competes for executives is optimal. If you look at other studies, like one by Mike Lipsitz and Mark Tremblay, they argue that you should see executives as effectively potential competitors. And if you think of a world in which an executive enters the product market as a competitor and prices fall as a result of that competition, it would be the consumers that benefit from that entry. And so if an executive expects that to happen, then they might agree to a non-compete agreement and not compete, and therefore keep prices higher in the industry. And then they would be able to capture some of the rents that instead would have gone to consumers. And so if you follow along with these sorts of lines of argument, then you end up with a situation where the harm to third parties are so high that that you can justify a ban on executive non-competes. And let me just give you one example of this. I don't know if we have any attorneys on the call, but if we do, you're probably very familiar with ABA Model Rule 5.6, which has been adopted in every state. And the practice of law is the only job in the whole United States where you cannot have non-compete agreements. And the justification, if you go read the justifications for that model rule, is in part that it inhibits the autonomy of the attorney. But the secondary justification, or maybe it's primary, I can't remember which order it was, is that it also hurts the clients. Because if an attorney has to sit out of the market because of a non-compete agreement, then the client is the one who suffers, because they are the ones who don't get to access their attorney of choice, and yet the client was not at the table when that non-compete was signed. And so that's the case of law. Lawyers, the ones writing these comments to the FTC, the ones writing these amicus briefs, they're free to go start their own company and join a competitor, start a competitor, but that's not true necessarily for the rest of us.
So there's a lot in there. I completely agree that uncertainty and just the uncertainty of which laws apply when, that's a net negative. And that's one of the reasons that a one size fits all makes a lot of sense. Or could make a lot of sense. It's one of the things pushing it towards a one size fits all. I'm a little bit worried about taking Evan's argument, completely. I completely understand the economics. There's spillover effects, there's externalities, negative externalities by not, being able to start your own competitor that therefore lowers prices. That's an externality on consumers. Usually within policymaking with antitrust, like that's not quite enough, because we could always say that by me staying at the firm voluntarily, when we together could have, or when I could have left and started a competitor, each time I stay at the firm, okay, voluntarily, that is a negative externality on consumers, that we are, internally colluding within a firm. We'd never force any CEO to have a 5-year turnover or something to get them moving. Right. And I'm not saying Evan wouldn't force CEOs to have turnover either, but the same models that have restriction of where lower turnover hurts consumers. You could spin it around that forced turnover in those models would help consumers. And that's not going to be a policy. And so it takes a little bit more than identifying an externality. And the question is the size, and this is where more of the empirical work needs to be. How big of an effect it is, how reliable of an effect it is, and can we systematically predict the effect? Not perfectly, but kind of do we have enough confidence to say, yes, this is going to net drive down consumer prices? And I don't think that the evidence is there yet.
Thank you both. And I think this is related to what both of you have just said, and we have alluded to this several times, which is the natural experiment, right? That has happened in states. What evidence can we summarize from those natural experiments? Do we see, does that shed any light on what, the uniformity ban the federal government is choosing here? So Evan, why don't we start with you?
Yeah, so, I think we have several of these experiments. Of course, you can look at California, North Dakota, Oklahoma as kind of long-standing places where we have these bans in place. The example of lawyers as well. So, there have been studies, one by Sarath Sangha, about how do you handle executives in California when you can't enforce non-compete agreements. And part of the answer is they still include them, but they then tie them to future compensation after they leave. Which would be a practice that I think could fall under a non-compete definition in the FTC rule. But that's how companies in California, they've been dealing with this in some ways for a long time. Even though they are still using non-competes, they know they're not going to be upheld in court. One thing on the natural experiments that I'll just say, which is that within a contract, you have these choice of law and choice of form restrictions. And if you look at the history of California's non-compete law, you have in 1998 this case called Hunter v. Application, where a California company hires a Maryland resident, basically. And the California courts say, okay, you can do that because we have this policy against non-competes. And that sets off kind of a hiring frenzy because now everybody's game and they can move to California. Well, that ends in 2002 in a case called Advanced Bionic versus Medtronic, in which a California company tried to hire a guy from Minnesota. And Medtronic filed in Minnesota. The other company filed in California. It's a race to the courthouse. And Minnesota finds first. And California says, okay, we're just going to go with you. And what happens after that is that every individual contract then has a choice of law and a choice of forum restriction in it, which says we're going to use another state's law. And so that's how companies in California are getting around this non-compete ban. And this is why state-level bans, like we've had in the US, coming back to this question about uniformity, are ultimately always going to be potentially less effective than a ban that we've seen before, because it gives companies a way out that they can still use non-competes. Now, states are getting around this. What they're saying now is if you're in Washington, for example, or you're in California, then you have to have protections under our laws. But that's not true of all states. And this just adds kind of another layer of complexity. And so I think if you take this as given, and you believe the empirical studies, which are of course subject to important criticisms, it suggests that what we're probably getting from these studies as it relates to innovation, wages, mobility, entrepreneurship, that we are going to end up with a lower bound on the effects relative to what we'd get with a full national ban.
Brian, is this an area that you agree?
Yes, in that the effects could be larger because of the forces that Evan laid out, absolutely. And that's the, one way in which the uncertainty point that I explained a little bit earlier plays out is I don't know which, I don't know if the court's going to be enforced. I don't know if it's going to be enforced or the contract's going to be enforced under California law, which it's not enforced, so on and so forth. One area in which I need to think a little bit more about this, but I think that also all of these issues make all of the studies a little bit more, we got to be careful with it. Yes, because Evan knows all this stuff and he's very good with different stuff, but it's all about relative changes. But a lot of the narrative around it makes it seem like these are really clear differences, that Oregon law is clearly separated from Washington law, clearly separated from Idaho, and so on and so forth. And this is what makes it a hard question, and all of the evidence gets contaminated by that. So the question is, what do we do? There's always going to be problems in any study. There's always going to be these sort of spillovers because you need to, for antitrust people, right? You need to define the market, and then you're just going to ignore everything else. There's no way to proceed if you're going to let everything, if you're going to say that Kroger competes with Target, like that's just not going to. You need to define the analysis, and it's the same thing that needs to happen in these examples. So I think that what that does is that raises the uncertainty or the ease in which you can map from the state to the federal. That could mean that the effects even larger at the federal level, but it also could mean that effects that we thought we estimated correctly are not as well identified as we would have hoped. Again, circling back, that means that I just don't think that we have the like total analysis that we would like on this sort of question.
Can I respond to that very briefly? So I think that Brian raises an important point, which is that all these studies, these state studies have limitations, there's spillovers. And in order to justify a ban, I guess if I just to extrapolate from what Brian was saying, you would have to have a ban. Otherwise, what Brian is saying is there's too many limitations from what we could possibly know relative to this federal space because of these spillovers and these sort of challenges. And so it feels sort of tautological to say, I can't justify a ban because we haven't had that experiment when we're debating whether we should run that experiment in the first place.
I think that's fair. And both of you probably predicted my next question, which is what studies would be needed other than you cannot just rely on natural experiments. And you have economists, we have people who were professionals to do these. So what studies do you think would need to be carried out to improve our understanding of the economic effects and potentially to influence policy? What findings would it, swing you a little bit, towards either way about non-competes? Evan, let's continue with what you just said.
Yeah, so I think that, what we've had over the last decade are several examples of not complete bans. So we've had these state level bans, which typically have earnings thresholds, and they've been set at very, very kind of arbitrary levels, from $13 an hour in Illinois in 2017, which they've subsequently updated up to, $150,000 in DC several years ago. Really, it was just this last year when Minnesota passed a complete ban and became the fourth state to ban non-compete agreements. Has the state gone that far? And I think in part that's actually due to the FTC being a little bold here in what they came out with in terms of their rule. And so I think that it would be really interesting to study what happens in Minnesota, what happens to executive non-compete contracts, what happens to firms, to workers. How are firms going to substitute when they've banned non-competes entirely for everybody in that particular state? So I think that it would be really helpful to have some of that evidence, some of it micro evidence on literally how are firms changing their contracts, and then thinking a little bit more on the downstream effects on consumers and what's happening to prices. Now, going back to Brian's prior point, it's possible that we can't generalize from there to a full ban because maybe there's some spillovers to local areas, maybe other things are happening in other states. And so even that is going to be tricky, but just getting some sense of how the complete ban helps. The other place I'll mention is this on alternatives. We focused in the literature on non-compete agreements a lot. And when you run surveys, you'll learn that non-competes are just one of many potential alternatives. We've asked in surveys about NDAs, non-solicit agreements, agreements not to hire your coworkers, training repayment agreements, intellectual property assignment agreements, no hire agreements. There's a whole ton of restrictions, and it'd be really interesting to see how companies substitute when you ban non-competes, if they keep everything else the same, or if they substitute in some way, shape, or form in terms of how they're going to protect their information.
Absolutely agree. We need more of those studies. So, to be clear, I don't think we need a nationwide ban to estimate what the effects of a nationwide ban are. I mean, yes, in some tautological sense, that's true. But I want something closer than we have, or a few more things far away, right? We're all trying to extrapolate from imperfectly applicable examples to a different example that hasn't happened. That's always the problem. You know, we're going to use a state level rise in minimum wages to try to make a prediction about what the national one is. That's the best we can do. But I certainly wouldn't want to. I'd be hesitant about advocating for a nationwide raise in the minimum wage based on, 3 changes in the minimum wage, and 4 changes that we've had a good study with, even add in the other policy changes that we've talked about. I want more. I want more to study. I want more episodes, but I also want more studies on those episodes. So again, Evan's got absolutely wonderful papers in this literature, but there are other ways to attack even the Oregon question. Okay, I'm not suggesting that there's anything wrong with Evan's papers, but there's anyone who studied a major policy change, whether it's taxes, whether it's minimum wage, whether it's R&D credits or something like that. Like there's different ways to attack the question, and I want to know more about that. Does that mean that we have to do analysis until we're blue in the face, until whatever the expression is, till the sky falls? No, of course there's a point for trade-off. One area in which I really want to see more analysis is in the theory side and on the welfare analysis side. Okay, there's not a ton of papers that take seriously welfare between consumers, workers, and the firms. Okay. Evan pointed out one that does, that maybe suggests a non-compete ban is optimal. I have issues I've written about with that paper, but that's a starting point. There's another paper that's been released that suggests that welfare goes down when you have a ban, even though wages go up. Okay, so how do we think about that? Again, not one paper is going to solve it, but I want more and more of these models. They're coming along, but as Evan said, like this literature started with him 10 years ago. Like that is the literature, and it's evolving.
I think that's very helpful. I did promise the audience that they would have opportunities to raise questions. We did get a few. Some of them might be a little mouthful. So I would probably ask this one and extrapolate a little bit about it, which is the question is, for the study you mentioned comparing NDA and non-competes, was it industry specific? And I think the question, a broader question I want to extrapolate from here is that, like, has the evidence or studies that we have seen so far being limited to a set of industries or sectors? Healthcare, for instance, is that like, sort of like a focus of policy enforcement? Like, what about the availability of evidence in different industries?
Yeah, so to answer the question, the study I referred to is a field experiment, which is in a specific setting, which is in the financial services context. But to your broader question about different contexts, if you read some of these studies looking at different bans, for example, Brian's mentioned this Oregon study that I wrote with Mike Lipsitz back in I think it's in 2022. And several of the studies, what they do is they cut the results by different industries. So what's the effect in this industry versus that industry versus this occupation versus that occupation, for women, for men, for whites, for blacks, for Hispanics? They break it by all these different ways. So there is a whole bunch of that. In the Oregon paper, we have a nice graph by quantile of the earnings distribution, so you can look at the effect according to each quantile. So a lot of these studies have documented some of this heterogeneity across sectors.
All right, well, we are at the top of the hour. So huge thank you both to our debaters for the time you spent preparing and debating here. I think this has been really, really informative. Great service to the bar to get this information out there, to get different perspectives out there. And a big thank you also to everybody who made time to attend and watch this program. Thank you very much.